Mr. Subramanian, just one small clarification I had.
Yes, certainly.
What
Please.
happened to the instrument as a matter of law? What happened to the instrument of accession after the Constitution of J&K came into being?
My lord, the accession, that instrument of accession, my lord, really speaking, after the Constituent Assembly decided to accede, it was ultimately, my lord, that decision which operated. The instrument of accession, my lord, was done initially in 48, as your lordships recollect. But in that instrument of accession, there was a clear reservation that I'm not making any commitment to abide by the Constitution. My lord, there were some conditions, reservations placed in it. But normally, my lord, if suppose accession had to take place through the Maharaja, then there would have been a supplementary instrument of accession and a merger agreement as was done with many others.
So once the Constitution of Jammu and Kashmir recognizes that Jammu and Kashmir accedes to the dominant status of India,
yes,
that it becomes a part of India.
Yes.
Would it be correct to say then really that instrument of accession ceases to exist as an independent document in that sense?
No, my lord, it did enable accession. For the purposes of sovereignty, my lord.
What would be the status of the instrument of accession once the Constituent Assembly of J&K designed and promulgated the J&K Constitution?
My lord, if I may say so with respect, the instrument of accession is a historical fact. It's a historical fact. I'm sorry, my lord. It's a historical fact.
Would it be subsumed in the state constitution?
Yes, my lord. Yes, because the state constitution itself recognizes the accession in 48. May I show that, my lord? May I show that? The constitution itself recognizes.
Is subsumed now in Article 370, and only to the extent Article 370 refers to it, it will be applicable.
It has no use after 370 because it incorporates those matters in 370 automatically.
Well, the instrument of accession was for a very limited purpose at that time. But, my lord, matters later on, as your lordships have seen, there was the Constituent Assembly and accession was complete. And the Constitution of J&K itself, my lord, has declared that integration to be complete. That was the decision of the people.
Mr. Subramanian, the reason I asked you was this. Now I'll tell you why I asked you this question. Could it conceivably be that the fetter on the power of Parliament under Clause B of Article 371 was also a limited transitional provision which would operate so long as the instrument of accession held the field as an independent document?
No, my lord, there is no evidence to that.
Once the instrument of accession gets subsumed in the post-constitution document evincing a transfer of power, then to the extent that the instrument of accession itself has been subsumed, then the fetter on the power of Parliament cannot be relatable to the instrument of accession, but has to be found somewhere else.
My lord, I'm grateful. The fetter, my lord, on Parliament is by virtue of 370 and my lord had no direct relation with the instrument of accession. If I may just point out, my lord, 370 was there as your lordships have seen in 1950. At that time, there was only an instrument of accession. After the Constitution came into force, it is only in 1951 that the Constituent Assembly was constituted. And then, my lord, the Constitution was finally enacted in 1957. But between 51 and 57, my lord, the instrument of accession, my lord, is already on the record. It is in document 1.
Yes, your
lordships have seen. And my lord, that is very clear that it is a period of transition. But that period of transition and the fetters being imposed on Parliament, my lord, that was not the cause of 370. If I may say so, I've understood what your lordships are putting to me, that before a new sovereign body of legislature takes complete effect, is it not correct that the old is wiped out, or there may be some a purely transitory provision? But this is not, my lord, a transitory provision. That is why, my lord, E 370 in its true essence is not treated as a transitory provision, but is actually a substantive provision meant to operate over a period of time. Then, my lord, it is clear that concessions which have been sought and granted by, my lord, again, by the Union government, by accepting the recommendations of the Constituent Assembly, I submit, my lord, with respect, then they get embedded into law by operation of 370, as well as, my lord, by virtue of Section 21A of the Government of Jammu and Kashmir Constitution.
Now, Mr. Subramanian,
Yes.
you've given us the
Yes.
Constitution Bench decisions.
Yes,
According to you, postulate the continuance of Article.
that's right, my lord. That is that
Your
Sampath.
point on Sampath Prakash as
Yes,
well
that
as
is para 8. Now, my lord, this judgment in Damnu, which has been cited, I just want to just take 2 minutes, and I'll take your lordships to Chief Justice Sikri's judgment, who makes a comment on this in Keshavananda Bharati. But, my lord, in Damnu's case, the facts were as follows, my lord. The Jammu and Kashmir Legislative Assembly amended the Constitution of Jammu and Kashmir in 1965 by the 6th Amendment Act. As a consequence of the 6th Amendment, they replaced, my lord, that expression Sadare Riyasat with governor. The amendment first took place, my lord, in the J&K Constitution. Therefore, my lord, in order to see that that was reflected vis-a-vis our Constitution and Article 370, there was, my lord, in the interpretation section, your lordships have seen, that was buried. That, my lord, was challenged. The amendment was challenged. The Constitution amendment, as well as, my lord, the order in amending Article 367, one of the explanations was challenged in Damu's case. In Damu's case, Chief Justice Sikri said that what has been done by the order explaining that the Sadare Riyasat is now governor is in conformity with the Constitution 6th Amendment of J&K, and therefore there is no impairment of their basic structure. But, my lord, the learned judge has actually, if I may say so, relied upon an excerpt in Keshavananda Bharati. In Keshavananda Bharati, where, my lord, the word amend was so widely worded, if your lordship sees one paragraph in Keshavananda Bharati, that is, my lord, that is Case Law Volume 15, and the relevant portion, my lord, which I wanted to show, is para 306, PDF page 174. And Chief Justice Sikri, my lord, refers to his own judgment. And he refers to it, my lord, to support the position that the fundamentals of J&K Constitution were not impaired. Please see para 306, PDF 174. Reference may be made to Muhammad Maqbool Damnu versus State of Jammu and Kashmir, where this court repelled the argument of the learned counsel that the amendments made to say...
Mr. Subramanian, just 1 second. You're on Case Law Volume 15.
1.5, my lord.
1.5.
Yes.
And the PDF page?
PDF page 174, my lord.
174.
Yes, 306.
Yes, Mr. Subramanian.
Yes, para 306, my lord. Reference may be made to Muhammad Damnu versus State of Jammu and Kashmir, where this court repelled the argument of the learned counsel that the amendments made to sections 26 and 27 of the Constitution of Jammu and Kashmir were bad because they destroyed the structure of the Constitution. The arguments of the learned counsel was that fundamentals of the Jammu and Kashmir state constitution has been destroyed. This argument was refuted in the following words. But the passage cited by him can hardly be availed of by him for the reason that the amendment impugned by him, in the light of what we have already stated about the nature of the explanation to Article 370 of our Constitution, does not bring about any alteration either in the framework or the fundamentals of the Jammu and Kashmir Constitution. The state government still continues to be the head, governor still continues to be the head of the government, aided by a council of ministers, and the only change effected is in his designation and the mode of his appointment. It is not as if the state government by such a change is made irresponsible to the state legislature or its fundamental character as a responsible government is altered. And then, my lord, please see the last sentence. There is no question of such a change being one in the character of the government from a democratic to a non-democratic system.
Right.
And, my lord, I submit with respect, when we look at the exercise of power under 370, my lord, it must be informed with the idea that it should not offend any of the basic principles of the Constitution. And the two principles which I invoke, my lord, are federalism, and my lord, federalism as its subsect has autonomy and consent. The principle of federalism, my lord, is always autonomy and consent. And the other principle, my lord, is supremacy of the Constitution. So supremacy of the Constitution here, my lord, I wish to point out that the purposes of 356 and 370 are not coincidental. They do not coincide. And because they do not coincide, the exercise of power under 356 cannot clothe you with legal authority under 370.